the technical sessions of the 5-day IFA Congress are all over. A 4th day of the technical session, and to sum up, what's been a very exciting conference, a conference full of discussions, insights on all the contemporary tax issues, some of what we call it the hot controversial ones. Always new perspectives emerge from these conferences, and we have some special guests to discuss what happened at the conference over the last few days, some of the key issues that emerged and the way forward. To my left, Michael Lennard, Secretary to the UN Tax Committee, a big man in the tax world, one of the key policy makers. To my right, a person who needs no introduction whatsoever, the one and only Philip Baker, Queen's Counsel UK, shooting straight is what we call him. And of course, my partner and co-founder of Taxsutra, Ameya Kunte. He is the person who's attended and brought us all the coverage over the last 4 days. So he'll fill in us with all the interesting tidbits from the technical sessions. I'll start with you, Michael. BEPS is still the operative word. That was the operative word 12 months ago.
Yes.
Where we are you satisfied with the progress and what emerged out of the discussions here on BEPS?
Well, I think first of all, I thought I was BEPS fatigued because there's been so much talk about BEPS. I've read so many papers, but I actually found it was good to get back to some of the technical issues because there's some bigger issues involved with BEPS. I think we're very supportive of BEPS, but looking from the developing countries perspective, we've always said there are issues which are not within the BEPS action plan which are important to developing countries. So I thought it was very good that in this conference we not only had the BEPS action plan discussed, but also other issues, including the UN panel, such as the emphasis on the UN on preserving withholding tax rights and the general source versus residency country issues which are not within the BEPS action plan. So I thought BEPS is going as expected. It's on time. There's still a lot of discussion about what particular approaches will mean, and I think as always for developing countries we have to be careful that they're involved in the design and the complexity and administrability issues are covered for them so that they can actually get the benefits of BEPS and not just the detriments in terms of their costs.
Philip, I thought I should read out from your article for us where you said the impressive output of the 2014 outcomes should not blind one, of course, to the criticisms that have been made by many people of the BEPS projects overall. The project is still narrow in its focus, essentially looking only at the direct tax treatment of a relatively small but highly significant number of multinational corporations. There is a world of tax policy and of international tax rules outside the scope of the project. Philip, you've been the critic number one, I think, over the last 12 months of the BEPS project. You're not impressed?
No, I don't think I have been the critic number one. All I'm doing is trying to put the BEPS project into some perspective and make it clear that it's not the only concern of international taxation for countries, and it shouldn't dominate all of the work of all of the international organizations in this area. There are a lot of other developments going on outside. For example, all of the changes that are going along with regard to exchange of information and FATCA and automatic exchange of information, that has nothing to do with BEPS.
You think that's getting relegated to the background because of BEPS? Not getting the deserved attention it does?
Yeah, I think that's right, actually. I think that the OECD is trying to get everything focused on BEPS, and there's a world of international taxation matters of concern to all countries and to all taxpayers outside of the fairly narrow area of BEPS. I'm not critical of BEPS. I'm a little bit critical of focusing too much on it.
Cross-border outsourcing to judges seminar, tax treaty override, latest recent developments in international taxation, and of course a topic which we'll discuss quite a bit, quite a few interesting views on use of non-tax agreements to resolve tax disputes. What were the key highlights as far as technical sessions go?
Sure. I think just one out of the 4 points that you mentioned, the treaty abuse provisions that OECD is introducing through BEPS, there are a series of changes introduced. One at the introduction of the intent clause, then the introduction of limitation of benefits clause. There is a treaty GAR and a treaty specific SAR proposed. you already have a beneficial ownership, and in addition to that, you have a domestic GAR as well. I think if you look at all of these points, while doing a transaction, at what stage the threshold is met is something which is sort of will be key from a business point of view and will be difficult to achieve. I'll be happy to have Mr. Baker's comment on should there be a priority in this, or will they apply in all directions to a business?
Well, one of the areas that was highlighted just now that arises from BEPS is the whole question of the conformity with European Union law. BEPS project is continuing and looking, for example, at treaty abuse without recognizing that a large group of countries have restraints on what they can agree to. And I thought there was a very helpful discussion taking that point forward. Maybe it's something that the OECD will now pay a bit more attention to, because they're heading down a road of potentially adopting measures which will then be challenged. Potentially, in effect, unconstitutional, because European Union law is, in effect, constitutional law for the EU member states. So, of course, if the countries are persuaded to adopt measures that are unconstitutional, they'll be challenged on those. That's not good for anybody, because it creates uncertainty until the European Court says either this is consistent with EU law or it's inconsistent.
Michael, one important point which is emerging is there needs to be a political agreement at the end of the day between 45-50 countries at least, and there already are emerging some not dissenting voices but some voices of concern on the interplay between developing countries and the developed countries. Are the priorities different? For example, the Indian Minister of State for Finance made an intervention at the G20 meeting recently and said that the voices of developing countries must be taken into consideration a lot more while developing consensus. So what role does the UN have to play here, Michael?
I mean, this is a very important point. Even when you talk about developing countries, there are G20 developing countries and there are non-G20 developing countries. And the world of the OECD and the G20 is, I think, 44 countries. We have almost 150 other countries in the UN family. So I guess it's inevitable, as we've already said, that there will be issues that are not in the BEPS action plan, which are important for a lot of those countries. And there will be issues even maybe within the action plan where the outcome will be not a priority for them, or will be not something that's easily administered. So I think it's been difficult because of the timelines to engage as much as we would like. We and the IMF and the World Bank and the OECD are very aware of this issue, and to my mind it's very important to have a really global outcome to ensure that there is the voice and participation of developing countries.
Are we going to see a multilateral instrument, a multilateral agreement at the end of this? Michael and Philip, I want both to come on, because at the end of the day, if we do not have a multilateral agreement, how is this work going to be reflected, at the ground level, and how are the countries going to implement it?
Multilateral agreement will be very difficult to achieve, and very difficult to achieve in a way that works properly with an existing universe of treaties which are all different. One thing I would say, and ultimately that's an issue for the OECD and G20, which is taking the lead, but it needs to be one that has wider acceptability. And I think it's important, for example, that even though the source residence issue is said not to be within the BEPS action plan, that any multilateral treaty not by default try to move countries which seek source country solutions and to preserving their withholding tax rights, for example, moves them more to a residence approach, because I think that wouldn't succeed.
But overall, we'll move from BEPS from here, but overall, are you impressed with the outcome so far? Are you happy so far with what's happened?
Well, we're supportive. I'm probably not close enough to all the debates to say whether I'm happy or...
You want to be more involved?
Well, I think it's always important that the UN be closely involved, and the OECD is aware of that. The IMF and the World Bank are also very important, and at the moment we're still trying to work out how we work together. Essentially, in the interests of our client, which is the developing countries. That's something we all have to address.
Philip, before we move from BEPS, 20 seconds.
Well, you asked before about the multilateral agreement. It seems to me that there are two truly valuable broader outcomes that may come from the BEPS project. One of them is the multilateral convention, and the other one is a much needed improvement in the methods of resolving international tax disputes. But let's just focus on the multilateral convention. If we don't get a multilateral convention, then frankly the whole BEPS project has failed. And I don't think it's that difficult. We have multilateral conventions in all sorts of areas: trade law, environmental protection, human rights. I don't see why tax should be that difficult there. And there's been some very good work done in the context of the BEPS project towards it. The real issue is what one tries to achieve with the multilateral convention. At the narrow end, what one can achieve is amending a large number of bilateral conventions in a very streamlined and efficient way. And I think that's probably what will come out. There is still the broader possibility that it will be used, the multilateral instrument, to try to make legally binding some of the broader aims of the BEPS. That I think may be harder to achieve.
Ameya, I think one key issue that's emerged, and in fact that came up today, is the use of non-tax treaties for tax, to resolve tax disputes, and there doesn't seem to be any consensus even among the panelists. There were quite a few divergent views.
Right. I think that's like Philip said. First of all, on a principle basis, there are precedents of non-tax treaties, and can they be adopted? And yesterday there was a extensive debate on the principal purpose test, which is being proposed in the limitation on benefit clause, and a lot of panelists expressed concerns on the application of the treaty relief with such a clause applying principal purpose test. And we have an OECD representative on the panel who gave an example of a recent treaty concluded by China in the context of investment, wherein the similar principles have been applied to grant the treaty benefit. This is of course non-tax, but I think the fact that there are successful precedents in non-tax situation perhaps gives some hope and confidence. Just on a lighter vein, on a panel of 6 experts, there was no consensus. I wonder how 50 people would come to a consensus.
But Philip, this is one of India's main concerns. The Indian Minister of State for Finance, in an intervention at the G20 meeting last month, said that arbitration is a sore point, that it impinges on India's sovereignty. Whereas on the other hand, you have OECD tax policy director telling us in an interview just a couple of weeks back that arbitration is a good deterrent to get outcomes from competent authorities. Which way do you look? Because there doesn't seem to be a consensus.
I'm sorry to disagree with the Indian minister, but states agree to enter into treaties or into commercial agreements which provide for arbitration. So you exercise your sovereignty when you decide to enter into those agreements or not.
Does it apply to tax cases?
Yes, there have been a significant number of tax cases. I was quite surprised. I found something like 40 tax cases over the last 50 years that have gone through arbitration, and they've been examining whether tax changes have been expropriatory or whether they've undermined the fair and equitable treatment. If India has a good case, then whether they're putting that case before a domestic tribunal or before 3 independent arbitrators, India will have a fair hearing and India will win. If India has a bad case, India will lose. That's not a question of sovereignty, it's a question of right or wrong.
Michael, a question on the fees for technical services. Ameya, UN has announced something, right, yesterday?
Yes, according to me at least, one of the key changes that is going to happen is the proposed new article on taxation of the services, and UN has initiated this project. I think next couple of weeks there is a discussion. We heard yesterday views from Indian representative on how the article should be worded, and there were clearly contrary views from the business side. I'll be I have a question for Mr. Lennard. 2 questions actually. One is that how do you sort of reached the consensus on with such wide-ranging options. And number two, it's again linked to BEPS in one way. You mentioned yesterday that right now, because of the resource constraints, digital economy is kept out of it. But isn't it a very important part to be dealt with since a new article is being proposed?
Yeah, first I'll just mention a little bit about arbitration. If as we heard, there were 6 different interpretations on a panel, there is no one fixed interpretation of anything. And I think the concern of developing countries is the way that arbitration works. The chance of an arbitration which is closer to their perspective might be less under arbitration than it should be scientifically. On the other point, the fees for technical services, you'll never get absolute consensus. But remember, fees for technical services articles are already out there. This is a way of saying, let's have a disciplined approach to those, and I think there could be a consensus that having certainty in this area is actually good for business as well as for governments. Even if business doesn't like such a clause, if a country is going to have one, it's probably better to have one that's been discussed and debated and that there's some regularity about how it's done in different countries.
Philip, tax disputes. I think world over, everyone is thinking, how do we reduce tax disputes? India is at the top of the ladder when it comes to litigations. In the last 6 months, since the new government has changed over, do you see a change in the mindset, a change in the approach? Anything different that you've seen in the last 12 months?
By the way, being at the top of the ladder on tax disputes is not a good place to be. You probably want to be near the bottom of the ladder on that. I haven't been following closely enough to see new disputes arising. I've been seeing the same number of judgments coming out, but of course those are disputes that arose potentially years ago and that are now coming to be resolved. What one wants to do in part is to try to make certain that disagreements have a method of resolution before they have to be referred to tribunals or to courts, and that means education, training, control over tax officials so that officials cannot take totally unjustifiable positions. If part of the reason why cases are going to court is because officials are simply having no control and just encouraged almost to take positions that eventually will be lost in the courts, but only after a number of years and a great deal of time and effort has been spent on them.
Philip, your take on inversions. I think that's the hot topic. The US is looking to pass a retrospective legislation on tax inversion. I think they'll outdo India there if they do. But your take, you think the concerns are justified? It came up today as well.
I think that's a US...
The definition itself was quite confusing about inversion.
No, I think people know pretty much the standard pattern of an inversion. I think that's a US issue, and I think one point that comes out very clearly from this conference is that US international taxation is overdue for a reform, and the rules about residents that lead in parts to the inversion issue is an element that needs to be reconsidered within the overall context of a US tax reform. It's unfortunate, though, that political position in the US makes it unlikely that reform will be carried out in the very near future, even though it is really quite an urgent matter.
Ameya, any question for Philip before we let him go?
Yeah, just last question. Last year's Copenhagen Congress, you were part of a panel which did a crystal ball gazing on how tax will look like after 25 years. And one of the key points, issues that was raised is whether arm's length principle will stay. And one of the view was that yes, it will stay, but the formulary will be called as arm's length principle. Do you still subscribe to that view after what happened in last?
Before you answer that, I must tell you, Pascal in his interview to us has said that it's become an academic debate, and we are not sitting here to settle academic debates. Is the debate academic?
No, I don't think it's an academic debate. I wasn't on the panel, but had I been, I would have expressed exactly the same view. The arm's length principle will gradually merge and become effectively formula apportionment under another name.
Philip, before we let you go, quickly, crystal ball glazing for the next 12 months before we meet you again in Switzerland. How will the next 12 months shape up in tax policy, tax administration, and for taxpayers?
Well, you see, the most important topic for discussion at Switzerland next year is the practical protection of taxpayers' rights, which is one of the CAIE topics. And I think there will be a greater realization over the next 12 months that with all of the developments on BEPS and exchange of information and transfer pricing and the settlement of disputes, taxpayers' rights and their practical protection have to be put absolutely at the center of the focus of attention.
Philip, we'll see you back soon. Thank you. Michael, continuing with you. Philip talked about taxpayer protection rights. That's going to get increasing attention over the next 12 months. Any work that UN is doing on that?
Well, we have an agenda item which is essentially relates to, let's say, taxpayer rights. But the committee decided last year when it was debated that it should also be discussed in the context of corporate responsibilities. So that will be discussed. Probably not this year because the agenda is actually so full. It was on the agenda this year. But next year I think that will be a very important topic.
Anything for Michael?
I asked a question around whether you propose to include the discussion on digital economy in the new article on taxation of service. Any quick word?
This is probably an area where, because it's such a broad issue, and partly due to the UN resources, but also it is under discussion in a group which involves a lot of interested players, including from some of the most interested developing countries, where I think for the moment it's a decision for the committee, not me, that the UN is likely to keep an eye on those developments. But I think it does merge with the issue which is not technically in the BEPS action plan of source versus residence taxation, which is of intimate concern to the UN tax committee and the UN family. So I think they'll keep an eye on it with that with that focus. For a lot of smaller developing countries, this is not their biggest issue. They have a lot more issues in front of it. But we were surprised when we spoke to developing countries that a lot more of them saw it as a priority issue than we'd expected, including some smaller developing countries.
One of the points, Ameya, to be observed is that the UN has got an increasing voice when it comes to tax policy making. You're happy about that, Michael?
I think it's where the UN should be, and I am actually believe in healthy competition, and the competition I think is good. We work with the OECD, they attend our meetings, we attend many of their meetings, and I think it's it's very important that we compete, as I always say, to serve the interests of our clients, which is, for us, it's the UN family, which includes developed countries, but it also includes particularly developing countries and also stakeholders, because we always say it's important for development of countries that they have the right investment climate. So if we can help countries make their own decisions, but if we can give guidance as to where on the spectrum between the high revenue take, at least in theory, and the investment climate, so that they have a good enough investment climate so that they can attract the activity which will build the revenue and build other aspects of development. That's, to us, a very important issue, helping countries make their own decision by giving them guidance so they can make the best.
Michael, last question, quick answer. Yeah. You enjoy a good working equation with India?
Yes, I do. I love coming to India. It's very hot. I'm sweating not because I'm concerned, but because it is hot in Mumbai. No, India is a very important UN country, and a country where I've actually learned a lot. And in the tax world, it's incredibly important because of the discussions and the quality of the discussions, the cases and so forth. So, important part of the UN family, and a country that I love being in India. I love everything about it, and I love the fact that I learn so much every time I come.
Thanks, Michael. I absolutely know you have to run. Philip is waiting for you. Thank you. Any final takeaways before we head for Switzerland next year? And that's going to be as exciting.
Yes, Arun. So a couple of points which came across in this Congress. First of all, a larger point in this source and residence debate. Somewhere even like Mr. Lennard mentioned, the source is getting its due recognition. I feel a lot of revenue officers from Indian Revenue who would have attended this Congress would somehow feel that their stand has been vindicated, and there is acceptance to this fact even by the Western world. I think that's one key takeaway according to me. And the second point is the automatic exchange of information framework that is going to come in just a couple of weeks at Berlin. Mrs. Bhatia mentioned about it in the morning today. According to me, again, specifically from an India perspective and a lot of developing countries perspective, I think this will also be a game changer. In fact, my take, BEPS, well, there are questions raised, but an automatic exchange of information will be a game changer in the international tax situation.
It gives the gun with a loaded gun to the tax administrators. On that note, that's all we have. From the IFA Congress in Mumbai, it's been an absolute pleasure and excitement for us to bring the Congress coverage live from Mumbai back in India after 17 years, and what a thrilling Congress it was. I hope you enjoyed our coverage as much as we did bringing it to you. See you next year. IFA 2015 is in Switzerland, Basel. Till then, goodbye from Taxsutra team. And yes, of course, before I close, I must mention that we launched a BEPS newsletter, and this is the newsletter. It's a bi-monthly newsletter. All you need to know about BEPS. Over the next 12 months, we'll bring out 6 editions dissecting the BEPS action plans, a lot of expert views, interviews with policymakers, corporate tax directors, the who's who of the tax world. You wouldn't want to miss this newsletter. You can log into taxsutra.com and download your copy. Till then, thank you.